नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां आज हम आपके लिए लेकर आए हैं एक नया लेसन।
Had a problem. I don't know what the problem is. I should check. But I myself could not enter the class. So it barred me. So the only way I had to make a new code. And I don't know why there is this limit, because earlier there was no limit. I don't know if they changed something over the weekend. So I had to get in myself. Okay. Now let's just continue with what we were talking. Therefore, in SP Anand's case. Now let's come to VR Kapoor's case, which is asking a different question. Now, in that SR Chaudhary case, before I leave, and I want you all to keep in mind, the question in SR Chaudhary was repeatedly, can I do a 6-month extension each time terminating the minister? And the Supreme Court gives us a very interesting argument, which I think as students of law you know. It says we will not apply the literal rule, we will apply the purposive rule of interpretation or construction. And this is an important weapon in the hands of a lawyer. That is, the rule says you have a 6-month window. If you applied it literally, then anybody who is having a 6-month is finished, then is unable to. Look, it looks like it's again got capped at 100, and I don't know what the problem is, because I have logged out of every other account and now I am only in my office account, so I've not used my account at all. So I don't know what the problem is. Really, I don't know what the problem is. So the literal rule has limited 100 for the free version. Acha. But till yesterday it was 250. Has the rule changed of Google, Priyanka?
Ma'am, the unpaid version has...
Oh, I see. So, well, the early bird gets the worm, so everybody has to enter. I don't know how else I can control it. Okay. So, college subscribed G Scoot. I don't know whether DU has paid for G Suite. It may have got the free version.
It has paid, ma'am. As long as you are the host,
because the other G Suite requires some money. Anyway, I'll check that.
Ma'am, as long as you are the host of this session.
Whether university, you can also try and check why this is so, and then we'll try and deal with it. Okay, now, literal or purposive interpretation. Purposive interpretation, who knows? Let's all try and find out. I see your point. Okay. Purposive interpretation, the purpose is not to create a fraud on the Constitution, but the spirit of the Constitution. So oftentimes you will find lawyers use this word, whether we should go by the letter or the spirit. Okay, and this is a good example of letter or spirit, because the spirit of the Constitution is that you're going to have a minister for your 5-year tenure, but you get elected only once, not that you do this repeat. So when you are a lawyer tomorrow and you want to develop an argument, then you will choose the mode of interpretation or constitutional construction that you will assist you, and you will say we should not apply the literal rule, we will apply the purpose rule. What is the purpose of the Constitution, and accordingly the words would be applied. Actually, this kind of thinking should become second nature to you as you are studying your 3 years. Which is the best argument? How will I choose my argument? How will I construct my argument? Which is the principle of statutory interpretation that I should use? So, this is something that every, your first year, your second year, your third year, going to keep studying. But these are useful tools to you, and if you look tomorrow, whether you're participating in a moot court or whether you are arguing something in class with me or you are arguing something in court tomorrow for your lawyer, these are the kinds of principles that you must study and keep in mind. Now let's move on to B.R. Kapoor. Rupali, I hope you have entered this class. Are you there, Rupali? Is Rupali there or she locked out?
I'm present.
Yes, Rupali, you're there. Can you give us the facts in 5 minutes of the case, please, that we are studying today?
Yes, ma'am. This is a petition against Ms. Jayalalitha for continuing as the Chief Minister of Tamil
Rupali,
Nadu.
are you there?
Yes, ma'am.
I can see Rupali here. Am I audible to all of you? She's speaking, but I can't hear her. Okay, but I can't hear her. What's the problem? And I'm scared to leave this call.
Ma'am, now am I audible?
Okay, so then continue. I cannot hear her.
Okay, ma'am. I'll continue. So, this is a petition against Ms. Jayalalitha for continuing.
I can't hear anybody. That is true. Yeah, Rupali, I can't hear you, but when you finish with the facts, then let me know. Okay. I'm sorry, but I'm just unable to hear you. Please continue.
So, the facts of this case are, so Ms. Jayalalitha was appointed as the CM of Tamil Nadu when she was not the member of any of the legislative assembly. She had been in her previous tenure, she had been convicted of some criminal offences under Prevention of Corruption Act. But for that, and she was convicted, she had paid fine for that, and the imprisonment had been suspended in her Am I audible?
Yes, you are audible. Yes, you are audible.
Okay, thank you. So,
Okay, are you done, Rupali?
No, ma'am, I'm
Okay.
as I
Can I
started
speak?
later.
Is Rupali finished? I'm sorry, but something is gone. I cannot hear. Rupali, are you done? No, Rupali is speaking? Okay, fine.
So previously she had been convicted and she appealed in the High Court against her
Okay, I'll
conviction.
give her a minute. Tell her in 1 minute she finishes.
So when she appealed, it is important to note that her only conviction was suspended. She was convicted, but it was only suspended. So suspension by the High Court was there, and then in the meanwhile, she for the current election, she contested from 4 seats, and she was disqualified from 3 seats because of disqualification. She incurred disqualification under Representation of People Act, Section 18, Clause 3. And for the fourth seat she was nominated from, she was disqualified because she had applied from more than 2 seats, which incurs disqualification.
No, I'm not muted. So, Rupali, I'm going to now speak. So, I hope you've finished. Muted my browser tab. What is that? No, I haven't muted it.
Rupali, she was on the bail, not suspension at the High Court.
Almost done. Okay, just take a 30 seconds and then close.
And when she in the present case, she not being a member of any of the legislative assembly, she was her party secured the maximum votes, and she was elected as the chief minister of the state. And this was challenged by Mr. B.R. Kapoor in this present case. So these are the facts in short.
Okay, so let me just take over from Rupali here. Rupali, I didn't hear what you said, but done. Thank you. Now let's look at the key points in B.R. Kapoor. To my mind, one of the points that I think is important for us to bear in mind is, the question arises whether the governor should have sworn in and allowed Madam Jayalalitha to be appointed as chief minister or not. Now, what the Supreme Court says is that the governor says that she was compelled. The governor actually was Justice Fatima Bibi, was compelled to appoint Jayalalitha because she was elected by the Legislative Assembly. Now, to that, what the Supreme Court says is that in the competition between, of course, you have to appoint the person who you think has the confidence of the House. That is Article 75(1). Look at Article 75(1). You will invite the person who has the confidence. She was elected as the leader of the legislative party. Yet, between that provision that she was elected, that is, will we give greater priority to representative democracy, or will we give greater priority to another constitutional basic structure, which is supremacy of the Constitution? Now look at, and I think this is a beautiful case to decide another broader issue. If you look at the Keshwananda Bharati judgment, and you look at the lead judgment, for example, of Chief Justice S.M. Sikri, he was part of the minority, but still, they all listed what they think is the basic structure. And one of the basic structure is supremacy of the Constitution, another is parliamentary democracy. Now, here is a case where parliamentary democracy is coming into collision with supremacy of the Constitution. So the Supreme Court says, merely because this lady was elected by the majority, and as for parliamentary democracy and under Article 75(1), she must be appointed. There is the supremacy of the Constitution, and the governor and the president are bound to uphold the Constitution. That's the oath that they take. So if you look at the oath that they take, it is to defend the Constitution. And a person who right from the word go is disqualified cannot be appointed. So look at they distinguish S.P. Anand, and they say that you can appoint a person as a prime minister, but technically, prima facie, the person must be qualified under Articles 84 and should not be disqualified under Article 102. Or if we're looking at the state, qualified under Article 173 and not disqualified under 191. Here, on the first day itself, she is disqualified. Why is she disqualified? Because she has already been convicted by a competent court. Secondly, she comes in appeal to the High Court. And what does the High Court do? It does not stay the sentence. What does it do? It stays the execution of the sentence. And that was fatal for Madam Jayalalitha. It did not stay the sentence, it stayed the execution of the sentence. And if you are merely staying the execution of the sentence, since we have looked at Article 72 in pardoning power, we looked at a word called respite. What is a respite? You postpone the sentence for a period of time, but the culpability or the conviction continues to remain. That's really what a respite does. Woman is pregnant, she has to be hung, capital punishment. You say, okay, for 9 months we will postpone the sentence. Or the person person has to undergo an operation. Okay, ठीक है, आप operation करके वापस आइए. After that, you will enter the jail. The conviction remains. It's not a case of a pardon which wipes out the culpability from the sentence remains. The conviction remains. The execution alone has been stayed. I'll come to this distinction again when we come to Lily Thomas, because there the court makes the point that if the sentence has been stayed, then the culpability goes away. But in this particular case, the High Court merely stayed the execution of the sentence. And as they say, that flaw was fatal for Madam Jayalalitha. This next point that the judgment makes is a very important point from Maru Ram's case. And in that great judgment, Justice Krishnaiyer says that when you go in appeal, does the normal presumption of innocence continue or not? Am I audible to all of you? Just type in and tell me if it's yes. Okay, great. Now, in Maru Ram, what the court asks is, when a person goes in pardon under Article 72 and the execution of the sentence, say, is postponed, there is a respite. It's postponed because you're waiting for president to give pardon or not. The conviction continues to hold in that period. He may not be sitting in jail, or he may be sitting in jail but may not have got hung. Suppose it's a capital punishment case. There is a respite on that particular sentence. But the guilt, the stigma, the conviction continue. Similarly, when a person goes in appeal, Sessions Court has convicted you for 2 years imprisonment, 3 years imprisonment. You go in appeal. When that appeal matter is being heard, the lawyers of Jayalalitha, the Advocate General of the state, argued that the normal law in criminal trials and in criminal appeals is presumption of innocence. In Maru Ram, Justice Krishnaiyer tells us that in the first trial, there is a presumption of innocence, innocent until proven guilty. But once a conviction has happened in the lower court and you go in appeal in the higher court, you cannot cutely bring up a presumption of innocence argument, because there is a valid conviction that is there and the court is still examining the matter. Till it decides the appeal finally, the order of the lower court will continue unless there is a stay on that particular conviction itself. And we've already seen that the High Court here only stayed the execution of the sentence. It did not stay the sentence. Therefore, there cannot be a presumption of innocence. That operates only at the level of the first criminal stage. After that, the conviction continues. However, assume that the appellate court decides that conviction is wrong. That conviction which is wrong, which is removed by the appellate court, will relate back to the date of the first conviction itself. There is a principle here. There is a doctrine of merger that appellate decision which says there is wrongly convicted will relate back. So ऐसा नहीं है. Let's take a hypothetical example. In 2002, the Sessions Court convicts a person. Then it goes in appeal. Is there a presumption of innocence? No. In 2006, the person now is declared wrongly convicted. Riha kar do. This will start not 2006, it will relate back to the initial trial itself. This is a principle which is there. But till that happens, he or she will be deemed to have been convicted till the disposal of the appeal case. And therefore, the court says that there cannot be a presumption of innocence, and therefore she stands disqualified under Article 191. The next principle that the court takes up is, can there be a writ of quo warranto issued against a constitutional authority, in this case the governor, for wrongfully inviting Madam Jayalalitha to become the Chief Minister? And there's a very elegant saying it's elegant. A quo warranto is issued against the person who issues the appointment order. And it asks the question, by what authority? That's what quo warranto means. By what authority did you appoint? Therefore, the argument here is, under Article 361 of the Constitution, no action can be taken against the president or the governor in their capacity as discharging official duties. So the argument, which I think is a very elegant argument, is that if Article 361 is there, how can a quo warranto be issued? Because I'm going to distinguish quo warranto from other writs. For example, the writ of mandamus. And see the difference here. If there's any question, because I don't have a mic, you'll have to type in what your question is. Look at a writ of mandamus and look at a writ of quo warranto. Let's take a case where the government appointed some person as an IAS officer as a result of the civil services examination. Appointment letter will be issued by the UPSC in the name of the president, and that person, he or she, will join the IAS. Okay. Now, for whatever reason, you found that this person should not be appointed. Maybe his basic degree was wrong, etc. You can ask for a writ of mandamus to quash this initial order, or a writ of certiorari to quash an order of a lower court. And you can say that there is an error apparent on the face of the record and this appointment must be set aside. Or tomorrow, let me take an even simpler case, that there is a admission has happened in law faculty and somebody has got appointed without having done an undergraduate. Usne bas 12th class kiya hai aur seedhe he joined. Whatever. There may have been a mistake of some nature like that. You will ask for a writ of certiorari to quash the admission of this particular student. Or a person has entitled to something and the government is not doing what it should do, you can ask for a writ of mandamus. Now, these will be writs which will go against the Union of India. Because remember, there's Article 300 which says, if you are challenging any action which has been carried out by the executive as part of the executive power of the Union, you will file in the name of the Union of India or the state of Tamil Nadu, as the case may be. Quo warranto is special, because you're asking that that appointment be quashed. And in this case, it's an appointment not of an IAS officer, which is done by the officer subordinate to the president. Remember what we've already studied. Article 53 read with Article 77. 53 tells us the executive order will be exercised by officers subordinate to the president. And who are those officers subordinate? Article 77 says that there are the rules of business and officers are exercising the power in the name of the president. So even the secretary or undersecretary can issue an order, and it's all done in the exercise of the executive power. But the quo warranto, appointment of the president is done by the president under Article 75. And similarly, the appointment of the chief minister is done under Article 164. And this is done personally by the president, personally by the governor, in exercise of their discretion given to them by the Constitution. Nobody else is there. There is no aid and advice, because we've already seen in Shamsher Singh's case that the appointment of the Prime Minister is done by the President personally in exercise of his discretion. So the argument now is that under Article 361, there cannot be a writ issued against the President when he is exercising his powers personally, because 361 is a complete. It completely prevents anybody from suing the president or the governor exercising in their name. And then what does the court say about Article 361? It says that this issue of quo warranto can be issued because the president is going to defend the Constitution. Therefore, the person whom he appoints should be somebody who is both qualified under 84 and not disqualified under 102. Qualified under 173, not disqualified under 191. And under 191, you are disqualified under any law made by Parliament. And under Article Section 684 of the Representation of People's Act, conviction for a period of more than 2 years will disqualify you for a certain period from standing for elections. Madam Jayalalitha was convicted and sentenced for a period of 3 years. And therefore the court says that, look at the article of, just one moment, I want to read out just these 2 lines about Article 361. The court says, I'm looking at paragraph 51, I'll just read out these 2 lines. If perchance, for whatever reason, the governor does appoint as chief minister a person who is not qualified to be a member of the legislature or who is disqualified as such, the appointment is contrary to the provisions of Article 164. And the authority of the appointee to hold the appointment can be challenged in quo warranto proceedings. That the governor has made the appointment does not give the appointee any higher right to hold the appointment. If the appointment is contrary to constitutional provisions, it will be struck down and the submission to the contrary must be rejected. Meaning thereby that notwithstanding Article 361, when such a case is made out, and look at what the language of Article 361 is.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।